So we'll get things kicked off here. Doha Mekki, thank you so much for being our guest today.
Thanks for having me.
I've got two former AAGs at the head of Antitrust Division at DOJ with me today. One also, Jonathan Kanter, happens to be the podcast intern now for us. Thanks for being here.
Sure, AJ, and I also just added Jeffrey Goldberg.
Oh yeah, I'm glad he's in on the. I'm glad he's in on the chat. It's a secure signal chat that we've got, and it's amazing to have you here. I got the great opportunity to have a nice conversation a couple of weeks ago with Jonathan about his story and how he got into the anti-monopoly movement. I would love to hear the same thing from your end. How you found yourself in the movement, and also like, was there an aha moment for you when you said, "Oh, anti-monopoly, that's what I want to be doing"?
So my story is a little unusual. I got my start in this life really like in law school. So when you're in law school, you spend a couple of summers working different places. And I spent my first summer at the U.S. Attorney's Office in my hometown, Charlotte, North Carolina. And I liked the feel of prosecution. So the U.S. Attorney's Office is essentially the chief federal law enforcer in a district. There's like 93 districts in the United States. And it was awesome. Civil rights prosecutions, white collar prosecutions, tax fraud prosecution. I mean, just all manner of things. And I realized then I was really like a mission oriented person. And so I graduated law school in 2011. So it was like a couple of years after the financial crisis. And I can't underscore this enough. I was really lucky to land at a law firm, right? Because that was a time of serious contraction. But I always knew that if I got the chance, I wanted to go to the government. And sure enough, about 3 years into my time at a firm, the government announced that it would begin hiring after a period of sequestration. And so if you think back to that time, Bill Baer was the AAG, Eric Holder was the Attorney General, and there was really a feeling of excitement around government in DC. And so I made the decision to apply and was really fortunate to get an offer at the Antitrust Division to start as a trial attorney, which is the best job in the whole federal government.
So, Doha, before we get into your experience at the DOJ, I want to kind of rewind a little bit. One of the themes that I've detected in various conversations over the last few years with people like you and so many others who are part of the anti-monopoly movement is that the financial crisis was a defining moment. And it really had shaped a generation of people who not only became distrustful of corporate power, but became concerned about the government's ability or lack thereof to contain corporate power. And I wonder if that experience was relevant for you, and if so, how, and how you think it might have affected your generation of now folks who have ascended to the peak of antitrust enforcement and policy.
Yeah. So, you know, the ethos that government should stay out of markets was really the prevailing kind of ideological force on like both sides of the political spectrum for basically my entire life. And then enter the financial crisis, where you basically saw a massive shedding of assets, a real hit on the middle class, untold harm to working class people and the working poor. And the policy decisions that the federal government made seem to a lot of people like a wealth transfer, right? And even if you don't totally buy that that is a decision, right, that the government made, you couldn't ignore the two-tiered recovery from the financial crisis. And I think that was the first time it really clicked for me that, you know, our experience in our market economy is really the result of a series of policy choices, right? Intentional decisions by the government to enact certain policies. And so I got more interested in why things were the way they are. And so I joined the DOJ Antitrust Division in 2015. And what was cool was at the end of the Obama administration, the National Economic Council, the Council of Economic Advisors, was starting to put out really interesting, provocative reports about why there was a two-tiered recovery from the financial crisis and why some people seemed not to be able to get back to par. And they posited that there might be non-competes, right? Stifling worker movement, that there might be no-poach agreements. Really, hat tip to my former colleagues at the Antitrust Division who uncovered a series of Silicon Valley no-poach agreements where Adobe, Apple, Google, Intel, Intuit, Pixar, Lucasfilm, and eBay had all had these like enmeshed no-poaching agreements. And again, in the process of untangling why the economy was not working for all people in this country, you really saw a change in attitude towards Silicon Valley firms, which if you can sort of transport yourself back to 2015, they were really darlings, right? Like the sense was that they were innovative, that their values were universally good, and that they were sort of meriting of special consideration, trust from the federal government, et cetera. And so I can't really underscore enough what a change was happening right as I was joining the Antitrust Division. And one of the first assignments I got to work on was the Antitrust Division's decision to challenge both the Aetna-Humana merger and the Anthem-Cigna merger, both of which were deals that threaten to really contract options in healthcare markets. And so again, you put yourself in the seat of, the ordinary person who might need the Obamacare exchanges to get healthcare, perhaps for the first time in life. And that really just ignited a sense that we at the Antitrust Division could be doing something good for the American people, not by prescribing outcomes or being overly prescriptive about really any market outcome, right? But just by making sure that markets were open, that they were unencumbered by monopoly power, by bad mergers, and so forth.
And so you're at DOJ, and then Trump wins, and Makin Delrahim brings you into the front office. And so this is just an incredible perspective that you have that no one else has, which is working in leadership and working at DOJ and sandwiched around the first Trump administration, two Democratic administrations, and being in leadership in the Trump administration and then the Biden administration. Tell us about, the differences in approach, philosophy. Tell us about that. That to me is just a fascinating experience.
Which age you like better?
Yeah, exactly. Let's get into that in the weeds. We'll bring Macon in next week. But yeah, anything and all the way into also, what your expectation is for Trump 2.0, but really focusing on the differences. I find that fascinating.
Totally. So you are right. I am probably the only person who is counsel and then principal deputy to Donald Trump's first head of the Antitrust Division and Joe Biden's head of the Antitrust Division, now podcast intern Jonathan Kanter. And again, going back to 2016, just remember some of the rhetorical devices and sort of policy that Donald Trump was stumping on, right, in 2016. And I think there's an unmissable populism of a kind, right? The idea that markets are rigged, the idea that, people are getting a raw deal, that he might have a solution. And, what's interesting is he seemed to be saying maybe government has something to say about how these markets are structured. And that's a huge break from orthodoxy, particularly for a Republican. And so Donald Trump nominated a guy named Makin Delrahim, who was the first AAG that I worked for, who, there's details in the Justice Department where you're a career official and then you get called up and can work very closely with the very senior leadership of the Antitrust Division. So the Assistant Attorney General, who's the top official, and their deputies. And that was a really great experience. We did not always have the same policy views, the same political views, but I always appreciated that, one, it didn't matter, and two, that I always felt like I had room to give the very best advice that I could. And I always accepted and respected that the decision maker is in fact the decision maker and would ultimately decide, enforcement decisions, policy choices, etc. Another aspect of the first Trump administration in the Antitrust Division that I found really interesting was that some of the more aggressive, interesting enforcement decisions really start under the first Trump administration. There was shock when they filed a lawsuit to challenge AT&T's acquisition of Time Warner, because at that point, it was the first what was called vertical merger challenge in 40 years, right? So not a merger of head-to-head rivals, trying to offer the same products or services, but companies that are sort of differently situated in the same like value chain. And then you see cases like Visa Plaid, right, where Visa was trying to acquire a technological upstart that was very important in terms of like the service that it provided to fintechs, right? And that merger was challenged, that was filed in federal court, and ultimately the deal was abandoned. And then after that, there was another deal called Sabre Fair Logics, where again, you just got this flavor of these tech companies trying to acquire important inputs that essentially could have allowed markets to flourish, whether it was in the back end that airlines and travel agencies rely on to like book flights, or whether it was like the backbone of certain financial services technologies. And that was unusual. Like that is not consistent with what people probably would have thought before Republican administrations would have been doing. Also, when Bill Barr comes in 2019 as the Attorney General of the United States, he gets very interested in the tech companies, right? And this is someone who sat on the board of AT&T, someone who was general counsel of Verizon, and I strongly suspect noticed a disparity in the regulatory environment for telcos, right? Like telecom companies and tech companies that were quickly advancing to offer similar services, right? And I thought that was also very unusual and very interesting. And so going back to 2016 and the election of Donald Trump, you have folks on the left who are really animated by the financial crisis saying these markets are structured in ways to benefit and aggregate capital and power in the hands of a very small number of companies. And people are made worse off, not only as consumers, but as workers. And the second and third order consequences of that power are an erosion of democratic values. And then you had folks on the right who also became interested in how government can structure markets, and they come to it from a different place, right? Like they're thinking about things like censorship and deplatforming and a sense that power is concentrated in the coast and really like 5 large cities in the United States, and the middle of the country was getting hollowed out, whether it was because of airline mergers that caused dehubbing or telecom mergers or broadband mergers, where the companies are saying we're going to bring broadband to the middle of the country, and then like falling through on those promises. Like people are getting more agitated, right? And they're looking to antitrust policy to offer some answers about why markets are not working and why their economic opportunity is actually worse off than their parents' opportunities. And so you see the opening of investigations into very large Silicon Valley tech companies, the filing of the first sort of big tech monopolization case, Google Search, which we oversaw the litigation trial of that. We are very proud that
and won.
Yes, we're very proud of the team. And I should put in a plug for all of the folks in DC. There's a remedies trial starting this month. And I will say that the DOJ fought very hard to make sure that there was open access in the courtroom. And that is a really important thing for anyone who's interested in these issues to be able to see firsthand. And so I think folks should try to get down to the federal district courthouse and see that trial.
I know we've been on a lot of those New York Times memos. Our lawyer has signed off on a lot of those memos to try to open up the proceedings. So
Yeah.
Definitely important for us. I know important for you, but and for everyone.
Totally. And if I could just go back, I
Yeah.
mean, look, there's a continuity, right? I mean, when
That's what I
Jonathan
wanted
and
to
I,
get.
yeah, when Jonathan and I landed in November 2021, I'm curious what you think, Jonathan, but it felt a lot like we sort of picked up a baton and just started running and said, look, the big tech stuff is important, but like, what about big healthcare? What about big ag? What about the cargo shipping conglomerates? What I mean, there was just monopoly everywhere, right?
I couldn't agree more. And I think now we have. Let's focus on DOJ for a moment. And you look at the sort of evolution from kind of Bill Bayer's time to Macon's time to our time and now Gale. And I think if you start looking at that in the aggregate, what you do see is you see really an evolution and change in antitrust enforcement and policy in a way of thinking, right? Bill, I think, really did kick it off with
Yep.
those two healthcare mergers, which were really, really important turning point. One where the agency litigated two major deals at once and won. I think Macon, while we may not agree on everything, he brought some important cases, the Google case, the Visa Plaid case, and it was a Republican administration alongside Judge Simons at the FTC that had a more pro-enforcement flavor to it. Obviously, I think we took that to 11, and now we have Gail and Andrew over at the FTC, and I do think we are seeing this kind of pattern of a shift. And so when we look back 50 years from now, I think people are going to see this kind of evolution a lot more clearly, perhaps, than people are seeing it in real time.
And you mentioned vertical specifically. Those are like routine cases now. That's not even like a controversial thing among staff. I remember questioning DOJ and FTC staff when I first started doing this. I'm like, vertical mergers are good. What are you talking about? That couldn't be further from what you hear from the staff now.
Yeah, if I may, just to,
yeah.
Because it's a little pet issue of mine, but my hope is that we get away from talking about things as just vertical and horizontal, right? Our markets are so much more complex and nuanced than that. We have platforms, we have multi-sided markets. Markets are multi-dimensional. Vertical and horizontal is it's like watching 4K video through a black and white TV. You'll see the outlines of what's going on, but you'll miss all the nuance. And I think we are evolving to make sure that the models and the tools that we use to address competition policy and antitrust actually reflect market realities as opposed to the other way around.
Market realities is the word that I was going to bring up. How does the market really work? I remember, again, going back 15 years when I started doing this, talking to people about, this merger. You're analyzing in a way that's disconnected from reality, right? The market analysts actually don't talk about the stuff that you're talking about. The lawyers on the deal are saying stuff that the market is not concerned about. And this market realities movement seems to be another thing that everyone actually wants to understand how the market works instead of talking about theory. And I want to take that. I want to ask Doha about how did that play out during Biden, and then how do you see the continuity continuing into Trump 2.0? Is it going to be a challenge? How do you see this unfolding here?
If I could just also throw out whether you had a similar early on in your career, you had a similar experience. Teddy and I did, and others, where you saw a kind of diversion between market realities and the frameworks.
Yeah, so I will say there was a matter that I worked on very early in my time at DOJ when, there were some horizontal overlaps that, the companies agreed would be spun off, but there was this concern about a pipeline product. And there was a lot of R&D. This was like
Explain what a pipeline product is for
yeah.
folks who are not familiar with it.
Yes, it was a product that was in development, right? So it was something that was very, very difficult to actually build. It was even more difficult to get certified because it went to fundamental issues of safety. And so when you're talking about innovating for something that is indispensable and important to protect the public, the amount of investment in that is really off the charts. Like, it's unusual, right? And it's a wonderful thing when companies want to break into those kinds of markets. But unsurprisingly, it can take a very, very long time. And in this case, it took many, many decades for a company to come along and even try to penetrate this market. And so, we thought we could structure relief to protect that innovation and actually bring it to market. And, we rolled up our sleeves, we worked with the companies, we worked with the lawyers, and we really did the best job we could to give this product a chance. And, you follow up on these fixes later, and sure enough, it was mothballed, right? It was put on the shelf. And that experience, I think, changed a lot of us who worked on that matter. And it made us more suspicious and not suspicious, like, sort of looking for bad intentions, but giving us a real sense that the approach was not working, and to be more circumspect about where and how we grant sort of approvals, right, to consummate transactions. And so I think that those types of experiences can change people. In our front office, right, Jonathan's in my front office, um, we had a mix of people that I think made us better, right? Jonathan and our deputy, Andy Foreman, had spent a combined like half century actually working with companies and had a real sense from the deal maker's perspective. And that was extraordinarily helpful, right? We had Hedel Doshi, our litigation deputy, who came from like, economic crimes and did consumer protection, and just was really, she did civil, she did criminal, right? And just had a really expansive toolkit for understanding adjacent areas of law, and how to tell stories about economic problems. And how to win in court, exactly. And then we had Susan Athey, who is the chief economist and had, advised CEOs, was a trained computer scientist, was running Stanford's AI lab, and also was a wildly accomplished economist. And so when we got together and were thinking about deals, we kind of naturally converged on, and I should say Michael Cadis was our other civil enforcement deputy, who, like me, had spent most of his career in government and just had a wealth of knowledge about prior approaches and stories about some of the most like famous antitrust cases that there were, right? Like things that we look to constantly, and just had this like on the ground view of like what happened. And so when we'd all get together and look at deals, we kind of converged on the sense that like we don't really care what the retrofitted explanation is. And we were constantly asking our staff, can someone please just tell us how this market works, right? Like, how are they trying to get a product or service sold? How do they think about competition? Like, where is the choke point, right? Like, where does it exercise power? If you assumed away power, right, what is the dynamic in the market? Now assume power, right? And what is the dynamic in the market? And just sort of what are the levers of power that we should be concerned about? And does this merger actually change, right, the lever, right? And so when you do that, you just get a like more serious, rigorous, richer understanding of how companies operate, why they operate the way they do, and how markets are actually functioning. And I think that approach, if there's any legacy that we left behind at DOJ, I would like to think it's that, right? And there's a SWAT team of 802 people as of the day I left, January 20th, who all think about markets in those ways and ask those kinds of probing questions about deals.
And that was the real, I think, innovation in the merger guidelines, 23 guidelines. Instead of starting the analysis by saying, is this vertical or horizontal? Or what are the markets and what are the market shares? We started the analysis by saying, how does competition in this market present itself? And is this merger going to affect competition? And if so, how? And then work backwards from that. And to build on Doha's really great explanation, we really did pursue a team-oriented approach at DOJ, one that brought people together from different life experiences, perspectives, and that made us a lot stronger. And I think that some of that had been missing in the past. I think there was always a lot of talent, but I think too often people would come from just one perspective or another. In recent years, it was the private bar, which can be a very valuable point of view. Certainly, you know how things work.
Well, that's where you came from.
Yeah.
Yeah.
But if you miss the litigator's point of view, if you miss the person who's been on corporate boards point of view, if you miss the person who's been writing legislation on the Hill point of view, if you miss the person like Doha who has sort of built from the ground up new areas of enforcement like labor and have been in the trenches as a investigating these cases and then supervising these cases, you kind of only have part of the picture. And I think by having the whole picture right at that front office, it allowed us to make decisions with greater confidence, greater information, but more of a 360-degree view.
I also love the story that at the staff level or your peers were brought along into this intellectual journey by seeing failure of the status quo way of doing things, which I think it was just a really hard thing for you two and Chair Khan to, even though there was some continuity, it was really a pretty big shift. I don't want to undersell what you did, which is shift a way of doing analysis among a big group of people who had a very set way of doing things. And it's just really interesting to see the story in real time of seeing a failed remedy help educate the staff to, hey, we've got it. We have to change this approach, right? If we want to be successful.
So you might tell a little bit of some of the stories, Scott, when we first got there and people started approaching us about remedies and kind of how that played out. Because I think it was humorous, but it was also, I think, a helpful vehicle to sort of reframe how we should think about these things.
Yeah, I'll be careful not to mention specific deals, but it seemed like the first month we were there, like a couple times a week, we would have meetings where staff would say, look, we think there's a violation of this decree, and these companies are behaving like clearly like contra the language in the decree.
These are merged. So just
yes.
Take a step back. Folks who come to us, and I don't mean to interrupt.
No, go for it.
These are mergers, right? So these are mergers that were approved with divestitures before we got there. People will come to us and say, hey, the divestiture buyer is either exiting the market, failing, going bankrupt, whatever it might be.
Right. Or there's a violation of like a behavioral clause, right? Like thou shalt not do, and then it turns out that, one of the merged party is like doing the thing. Right. And so to say, okay, great. Is there a decree? And they say, yes. Well, does the decree protect us? And the staff say, well, no. And we dig in.
It's so insane. It just, to me, I always think about, consent orders are not suggestions, but like, to me, that just is so insane.
The divestiture is the remedy, right? And so if someone sells a business, and then that company that you sold or the business unit goes under, or they change their mind, now you're left with a monopoly, and there's nothing you can do with it, because in many instances they've actually complied,
right?
Because compliance is just making the sale of the assets to get the deal done. So there's nothing you can do. Your hands are tied.
Yeah, and there's a point that I think people often miss, right? Like, I think there were many complaints about the Biden administration's approach to consent decrees. But again, one of the cool things about having worked very closely with, again, Macon and then later with Jonathan, is that I watched the first Trump administration work so hard to make decrees more enforceable. I mean, really, AG Delrahim, to his credit, did more innovative things than I've ever seen with decrees, right? Changing the standard for proving up violations, making sure that, I think they tried to modify a consent decree towards the end of that administration. And I mean, they really worked hard at this, and it just could not be done. And so, again, when we came in and saw these decrees that failed to protect the American people, you know, it was not on a blank slate, right? This was not greenfield. Like, this was on the heels of an administration that had already changed them ostensibly to be more enforceable, and it still was not working.
So what do we do?
You describe it. It was,
No,
no, it was your innovation.
No. We did together. Go ahead.
So, one of Jonathan's first speeches when he was confirmed to lead, after he was confirmed to lead the Antitrust Division, was to talk about his approach to remedies, right? And there were a couple of guideposts for what would be an effective remedy. That remedies would need to be offered early, that they would need to be comprehensive, and that they would need to really control for the market power or monopoly power concern that animated, the need for a decree or consideration of a potential challenge in the first place. And that essentially it would be the rare case that there would be a comprehensive decree that fully controlled for the market power or monopoly power concern of an otherwise illegal merger. So you should take it from there.
No. So I'm really curious. What was the response from the private bar?
People were not happy.
Why do you think that? I mean, I have my, I go back and forth on, why they're so upset by this. And we've talked about, this is a bit of a theme on the podcast, but why do you think they were so unhappy? Because there's definitely different things going on.
I think there are a few vectors. I think that there is a business model that has grown up around presenting otherwise illegal mergers and then trying to fix them ostensibly with a consent decree, right? So mergers are very, very lucrative. Like, there's entire ecosystem of merger, sort of like money that flows from mergers, right? There's the financiers, right, that actually help structure these deals. There's the law firms, like the M&A partners, that help get them to a merger agreement. There's ERISA advising, there's tax advising, there's labor and employment advising, there's the antitrust advising. And so, it spins off, a big merger spins off a lot of fees for firms. And so, unsurprisingly, that is very important source of work for the really incredible law firms that are all over DC and New York and other places. And so if you are now having to consider antitrust as a real potential holdup for a deal, it means that it can't be an afterthought. It means that you can't present a facially anti-competitive deal to the agencies and expect that, you can just get it through, right, with some number of concessions. You're having to think about it up front. And actually, I remember when Jonathan and our chief economist, Susan, really forced us to think about these incentives, right? And thinking about the fact that, sellers want certainty of closing, and the fact that, maybe the calculus changes or antitrust is taken more seriously up front, maybe when the board is considering a merger, was a very, very big deal. And so there was a lot of unhappiness, but I think ultimately it did change the incentives. And we heard that anecdotally, right? Like, when we would hear from financial advisors and deal lawyers who are saying, antitrust used to be an afterthought, and now companies are considering it up front. And again, this is anecdotal because the study hasn't really been done, but I point to a couple of data points. The number, the deal volume, was consistent with historic levels, right? In FY20 and FY21, we saw historic merger volume, right? Money was incredibly cheap. There were these debt finance deals. The COVID environment just sort of, it set the M&A deal making landscape on fire. But after that, we were seeing about 1,900 notified mergers to the agencies every year, which again is about consistent with what we were seeing in the past. We were also seeing fewer deals with hair, by which I mean just like facial competition problems. And so what we were hearing again from the financial class that was structuring these deals in the first place was that companies were choosing different merger partners, right? And so if there's one merger partner or acquisition partner that presents a lot of antitrust risk, maybe you're foregoing that and choosing someone different, right, for the transaction, and you have more sort of certainty of closing because there are fewer antitrust risks. And that is very good because that gives the companies themselves more certainty and more control over what their experience is getting a deal through. And it also means that the Antitrust Division and our colleagues at the FTC are expending fewer resources, again, on facially anti-competitive deals.
Right, and that really did free up resources to focus on other things. If I may just shift a little bit, Doha, you really are the most innovative lawyer probably I've ever worked with, but the pioneer of labor antitrust enforcement as we know it today. And I thought it'd be useful for people to kind of hear about how you came to that issue. You alluded to it earlier in your backstory, and then kind of walk us through the evolution of labor antitrust, which is something right now that is, I think, it is now in the water. It is a standard part of our merger analysis, our conduct cases, our criminal enforcement, and really taking a hold globally, but was really just an idea in your head when you started.
As always, I think that's an overly generous sort of restatement of what happened, but it is true. I spent a lot of time thinking about labor antitrust issues, right? And what antitrust was supposed to do in labor markets. The origin of this is I was working on a merger and we uncovered really a couple of conspiracies, but one was a no-poach conspiracy. And this was in 2016 and fairly early in the investigation. The DOJ and FTC released guidance explaining to the public that essentially there was no difference between a no poaching agreement, right, where two or more companies agree they're not going to solicit, recruit, hire each other's workers, and wage fixing, which is exactly what it sounds like, and market allocation, price fixing, which had been felonies for decades and illegal under antitrust law for more than a century. And this was a really big change. And the matter that I worked on was kind of the last labor market conspiracy to be grandfathered in under sort of the traditional way of looking at these things, which is, as a potential civil violation of the Sherman Act. But in the process, I learned a lot about why companies might agree to these kinds of things, the lengths that they went to make sure their employees didn't know in some cases, or in other cases, like it was so ingrained in the business culture that it's impolite or unethical, right, to compete for workers, that it was almost open and notorious. And so when Macon came in again, he was Donald Trump's first head of the Antitrust Division, he made a decision to continue that policy. And he asked me to come up to the front office and serve as his counsel. And I worked on a lot of things. I worked on healthcare. I worked on tech markets, digital markets, and sports. But really, he was like, can you build out a framework for labor? And I thought that this was just going to focus on criminal labor market conspiracies. This is 2018. Around the same time, folks like Ioana Marinescu, who eventually came in to be our principal economist, folks like Jose Azar and Evan Starr and Marshall Steinbaum and others were contributing to this really exploding body of literature from the labor economics world, kind of looking to antitrust as an explanation for why, again, there was reduced like wage earning, there was reduced labor mobility, and all of these pathologies in the labor market. And one of the more interesting findings in these papers was that employers could exercise control over workers at a much lower market power threshold than in product markets, right? So even if you're not controlling 60, 70, 80% of a labor market, that you can still have outsized influence over your workers. And what does that look like? It looks like being able to extract more hours of labor. It looks like being able to offer worse benefits, right? And this is a monopsony problem, right? Like Joan Robinson pioneered this theory in like 1935, right? And so this is like a known problem in economics. And so at the same time that I was working on um, investigating no-poach and wage fixing conspiracies, I also got more interested in non-competes, in abuses of bargaining power, right, which was a monopsony issue. I got more interested in college sports. We did a labor market, a labor workshop, and invited a speaker who had been a Division I basketball player, who really put on the radar this idea that maybe the NCAA has monopsony power over college athletes. And in fact, that idea was vindicated in the Supreme Court. And I was really excited to get to work on the United States' brief in support of college athletes to the Supreme Court. Obviously, we're really happy that that decision came out 9-0, right? The court unanimously is saying the NCAA can't price fix at zero college athletes' labor. And so this idea, again, was very resonant with a lot of people. Um, it was very unusual. Again, going back to this like convergence on antitrust, it might have struck some as unusual that a Republican administration really allowed these ideas to be nurtured and to be seeded and to grow. And, thinking about my friends Gail Slater and Andrew Ferguson, both of them are very interested in antitrust's role in protecting labor markets, right? Um, you know, Gail was confirmed a couple of weeks ago, and her first sort of big high-profile meeting was with Sean O'Brien and the Teamsters, right? Andrew Ferguson directed his heads of the bureaus that constitute the FTC to stand up a comprehensive labor effort. And again, having done that at DOJ, I think this is hugely important and a great source of continuity.
Can you walk us through some of the achievements and developments that we took on during our time? I think there are a bunch, and you were critical in leading that and guiding us there.
On labor or just general?
On labor.
Yeah, so I testified just to like set the stage a little bit. I testified before the House Antitrust Subcommittee in 2019, and in my written testimony, I talked about the different ways that labor problems can manifest as antitrust problems. And I talked about mergers that could harm workers. I talked about information sharing, criminal conspiracies, and at the time, a lot of this seemed theoretical, right? There was a lot of resistance to this idea that antitrust is properly concerned with labor markets. Even though it shouldn't have been controversial, I think there were some that thought this was like maybe not a high value use of antitrust policy. And so, during our time, we saw the filing and trial of the Penguin Random House Simon & Schuster merger challenge, which was the first kind of pure play merger challenge that went to a trial on the merits and reached decision and successfully demonstrated pure play labor case. Yes. Sorry. And again, to unpack that a little bit, when you hear the DOJ challenge the Penguin Random House Simon & Schuster merger, you might think, oh, they were concerned that the price of books would go up, right? But that was not the theory of the case. The theory was that author advances might go down if these companies are allowed to merge. And again, thinking about the second order consequences of an otherwise illegal merger, a small number of companies should not have outsized control over what ideas like reach the market. right? And again, going back to our friend and former colleague Hetal Doshi, she really structured that trial to put on literary agents who testified that, without those advances, right, to fund and nurture ideas and keep authors afloat for the years that it takes sometimes to write books, that some voices, some ideas, some stories may never get told. The first witness in that case, I have to say, was one Stephen King, who testified in support of the government's theory. And it was very important, both because it's a first, it's a labor market focused antitrust challenge, but also the storytelling impact of that case was hugely important. Um, Fast forward, maybe 6 months later, we had a conspiracy of meat processors, right? People who process chicken to be distributed to grocery stores and sold to American families, that were exchanging wage and benefit information of slaughterhouse workers. And these were wildly vulnerable individuals, some who did not speak English, some who actually testified that they were taking like drugs, in some cases amphetamines, in order to be able to keep up with the manual labor required to work in a slaughterhouse, like a chicken slaughterhouse facility. And we were able to really ride atop this class action that had been filed to make sure that they get money back. And so, as part of our consent decree, we not only made sure that they set aside 85 million bucks for affected workers, but we banned the intermediary from the industry who was really facilitating the exchange of this information. And we also mandated changes to the now notorious tournament system that really kept chicken growers and farmers down and kind of rigged the game for them. And they're often taking out huge loans to finance the stuff. Later, we come back. We filed the Cook Foods case and made sure that when meat processing plants close down, that they are treating their contract farmers fairly, that they are not being screwed over by contract terms that leave them holding the bag when the processors go out of
The
business.
ability to shift back and forth.
Exactly, exactly.
A couple of others, esports, maybe 30 seconds.
That's true. We did a consent decree with Activision Blizzard. They had an esports league over the Overwatch game and Call of Duty, and they essentially imposed a salary cap. And we said that's, again, a violation of the Sherman Act, but also included a provision that required them to maintain neutrality if and when the workers ultimately decided to unionize. We also secured the first criminal conviction, in a labor market case. This was hugely important to me, having indicted the first ever wage fixing conspiracy. And this involved school nurses for special needs kids. And I cannot underscore enough how much the documents in that case impacted all of us in the front office, including seeing materials where nurses were saying, if I can just get $7 more per hour, I can afford healthcare.
I won't say it for confidentiality reasons, but I remember that woman's name, and I'll never forget her name because it was a really powerful moment to see that in writing. Opera, tell us about opera.
Yes. So we also filed tons of amicus briefs and statements of interest coming in on the side of workers who were challenging, in some cases, non-competes. And in this one case that the NLRB was working on, we had opera workers, and we filed a statement of interest in that case to say that when workers are misclassified, it can deprive them of lots of different rights under law, including the ability to organize without fear of antitrust liability. But also that misclassification may be a standalone antitrust violation, because when one company, especially companies with market power, organize to misclassify their workers, it actually imposes a tax on companies that are complying with the law. And that follows from a California state court case called Dynamex that is really interesting, and I suspect will get more play in federal courts as more people try out these theories.
It's almost an unfair method of competition.
Exactly.
Can we? Oh, go ahead.
Merger guidelines, labor.
And there's a standalone labor guideline in the 2023 merger guidelines. Again, there are folks who say rightly that prior iterations of the merger guidelines also provided a pathway for understanding that, labor market concerns and other what are called buy-side theories could be challenged under Section 7 of the Clayton Act. But I think what the 2023 merger guidelines did was make it super, super clear that a merger that harms workers may well violate Section 7 of the Clayton Act.
I should also say that this classification certainly can be an unfair method of competition, but it also can be a violation of the Sherman Act, as well as state antitrust ethics.
I want to stay on labor, and I want to bring back to this Trump 2.0 question because you mentioned the continuity in a lot of ways. The merger guidelines were kept. The HSR form was kept. We've had both Slater and Ferguson talk about labor as important. However, at the same time, and remember Biden obviously famously had an all-of-government approach to competition. That has not been repealed yet, that order, as far as I can tell. But there is some areas of Trump 2.0 where there is not continuity, particularly on the regulatory front. Deregulation is a huge theme for the second Trump administration. That includes deregulating some labor protections at NLRB. The staff there is going to be very different from what we had with the Biden administration. They've already pulled back. They've already said they want to change the rules for line speeds in meatpacking plants. Are you concerned that are you concerned at all with that, with what you're seeing so far? But also maybe talk about why you think there is some continuity in some places and not continuity others, even though there's sort of agreement, obviously, at some level that labor is an antitrust concern, but that vision is not holistic.
Yeah. So I think there are things to applaud for sure, like the continuity on merger guidelines and HSR form, and an interest in greater antitrust enforcement. Obviously, it's difficult to really bring a whole of government approach to safeguarding workers, for example, when whole agencies are being gutted and when there's sort of inconsistent policy making there. I do have to point out the Biden administration in our tenure did file certain comments to regulatory agencies asking them to revisit what we viewed as potentially anti-competitive regulation. We did that in the energy space and in other contexts. And so it's not like we completely shied away from, regulations that could be anti-competitive. But look, I think that you can't miss some of the inconsistency in Trump 2.0. I think it remains to be seen where their policy vision ultimately will settle out. But I also have to point out that both parties have factionalism, right? Like there are, this is the problem with the duopoly in our political parties. These are really big tent political parties, and they bring together people with different policy visions. I think that was absolutely true of the Biden administration. I think we lived that firsthand. And I think it's true of the Trump administration. You see different folks, you see sort of what I'll call sort of crudely the Elon wing of their party, firing federal workers and expressing interest in privatizing a lot of services that had previously been performed by the government. And then you have folks like Steve Bannon, who is, in public settings, on podcasts, in print, praising the Biden administration's antitrust efforts and really expressing a lot of suspicion about a group that he calls the techno-feudalists, right? And I don't know where things will ultimately shake out for them. I suspect there may be frictions between those groups, but I think, again, that's what makes antitrust so interesting because it largely accepts that factionalism exists and there's nonetheless bipartisan convergence on antitrust enforcement, even if it may take a different complexion in the Trump administration.
And you're one of the only people that has seen intra-administration conflict in the Trump, from an antitrust perspective in Trump 1.0, Biden administration, and now you're on the outside now, but Trump 2.0, obviously there's this intra-administration, intra-party conflict. What do you think is different about the first time when you were in the Trump administration versus now? Obviously, there's intra-party conflict, but they're sort of different factions. It feels different, and I'm curious to get your perspective on whether or not it's different, how it's different. What your take on it is.
Yeah, obviously, I'm not in government anymore, and so I don't have a firsthand account of how things may be playing out differently. But as a private citizen, I think the one thing you can't miss is there is no pretense. They believe that you can use the machinery of government to effectuate certain policy ends, right? And whether it's antitrust or tariffs or immigration, I mean, they are using the machinery of government in ways that we have not seen. And again, I'm curious where all of this goes. Antitrust is a small island in a sea of federal policies, some of which I agree with, some of which I very strongly disagree with. And so I will be curious how they make decisions about which monopolies to pursue, what mergers to challenge. Obviously, it was a very interesting choice to challenge the HPE Juniper merger. That was one that we watched very closely, having spent some time with it. Um, but I think as they start to put their gloss on antitrust enforcement and their priorities, I think we will learn more about how much support there is in this administration for certain kinds of antitrust enforcement.
There's a deal right now. Paramount is being bought, and there's an FCC proceeding on that. And one of the remedies that's being discussed, this brings up communications market, it brings up the remedies conversation we've had, is an ombudsman to ensure that conservative voices will be heard and prioritized or get certain kind of weighting at the media entity. I'm deeply confused by this as a viable remedy, just because there is such
Taking out my popcorn right now.
such stark concern in the Republican Party about censorship, and I hear government approved ombudsman. That's the first thing that comes to my mind. I know other people think, oh, well, there's plenty of ombudsmen out there at media entities. Still, I can't. I have very difficult time with this intellectually. Both some of the continuity that we've talked about is a disregard for behavioral remedies or disregard for any kind of remedy that's not structural. And here you have something that just completely flies in the face of all of this. What's your reaction? Concern? Makes sense? Please, both of you, I'm curious.
I'm just an intern here.
You should answer in the first instance, Jonathan.
Listen, I will answer the same way I answered, I think, at my confirmation hearing and every interaction since, which is that competition leads to a diversity of viewpoints and ideas in the marketplace, and that is highly desirable, especially in information markets that are critical to the free flow of news and data and information that contributes to the political discourse. It's really the essence of what we are as a free society. And I would much rather, in the first instance, make sure that we're keeping a wide range of ideas available so that people can choose and vote with their own feet about what information they want to get, what they want to listen to, and where they want to listen to it. And so my value, at least my view, is that we should focus on preserving competition because it yields more opportunity, more speech, and more competition in the marketplace of ideas. I think it becomes a very slippery slope if we start picking winners and losers and picking ideas themselves. And so I'm sympathetic to somebody on the right of center who says they don't like the idea of concentrated media around left-wing viewpoints. I'm similarly sensitive to people on left of center who are concerned that they don't want concentration of ideas on the other side. And to me, the best solution is that to make sure that we have a variety so that people can get lots of information from lots of different places.
So I agree with that 100%. I think that reflects our viewpoint that it is much better to preserve open, vibrant markets that yield that kind of, range of viewpoints, right? As opposed to being prescriptive about what kinds of viewpoints are available. I'll say that the FCC's authorities are also different from the antitrust divisions. For example, and I know it's, this is under review. It's not clear whether this is, the ombuds idea is actually going to take hold. That might be the kind of thing that I would be alarmed to see in an antitrust consent decree, right? Those, you're on record as saying those kinds of social and political goals are really inappropriate for an antitrust review or a decree. Zooming out a little bit in terms of like consistency, inconsistency, I mean, a lot of what Donald Trump campaigned on was an aversion to censorship, right? And I think that resonated with some people in this country who felt like their language was being policed in ways that they did not like. And I have some sympathy for that idea. I think it would be incredibly disappointing and dangerous to enact policy or support policy that may replace one form of acceptable speech with another, right? And so these are things to watch for. And I think for all of us who really covet and prize our First Amendment liberties in this country, it's a thing that I love. It's a thing that makes me very proud to be an American. I would hate to see that kind of erosion of speech, and particularly to be policed by the government using the machinery of government, the force of the state. I mean, that sounds like two things that most conservatives will at least tell you they really don't like.
There's another aspect of communications industry, and obviously we could get into a whole thing about big tech, but I want to just focus on Musk for a second because he controls a communications platform and is in the government. And I know you've done some work on rule of law, and how concerned are you that, ostensibly it seems like the rules don't apply to some people, or that there's conflict of interest concerns that are being swept under the rug, and or what's your view on Musk and his control over the communication platform, and what can be done to address that seeming problem, or do you not think it's a problem? I'm just curious.
So let me zoom out because you mentioned rule of law, and all of us who grew up as lawyers in the executive branch sort of spend a lot of time thinking about this. I gave a speech in March 2023 about writing an antitrust. And one of the points I made is that there are rule of law considerations in what prosecutors do and what government officials do. Rule of law is this idea that we get from Aristotle. And the basic precepts are that the key to rule of law is that laws be sort of announced widely and equally enforced, right? The former Attorney General of the United States, Merrick Garland, used to say, we can't have one rule for friends and one for foes. and we have to enforce the law without fear or favor. And that's a tradition that's lived in the Antitrust Division for a very long time, including when the great Robert Jackson, former Nuremberg prosecutor, was the head of the Antitrust Division. Rule of law also yields a lot of benefits that people of all stripes really value. Rule of law makes sure that we are protected from violent criminals, right? Rule of law makes it safe to invest in markets, right? And when you threaten the rule of law, when you make people unsure about how the law is going to be applied, whether the law will be wielded to protect you, right, and protect your rights, it can have ripple effects with untold consequences. And my fear is that some recent events in Washington really destabilize the rule of law, right? As of now, we have courts that are taking action and issuing orders that all of us who grew up at the DOJ know that when courts rule, you must comply with those orders, and that there's a proper place for appeals, and that appeals can be exhausted. But until then, the primacy, the centrality of rule of law is so important in all forms of law enforcement. And again, I'm watching very closely because I think there are real concerns that in other parts of the federal government, concern for rule of law may be threatened.
If the executive branch disregards courts, then our whole way of life is over. I mean, really, rule of law is our backstop. It's what gives us the confidence to speak out, to be who we are, to live freely. It's a backstop to our economy, right? Because we know that ultimately there are going to be lines on the road, and people are going to stay in their lanes. And if they don't, they will be held accountable. Once that goes away, we cease to exist as a country, or the country that our country as we know it ceases to exist. And so I think, to me, this is existential.
I actually want to stay on this for a second for a couple of reasons. One, having dealt with Wall Street one way or another for the past 2 decades of my life, as a customer or working there, they seem to care a lot about the rule of law, contract law in particular. And we've got this huge trade fight now, where ostensibly the president wants to cut deals. And it seems hard to cut deals when you have questions about the rule of law. How do you see, how do you see the other parties, influential parties like Wall Street, or influential lobbying groups, industry groups like Wall Street and things like that, weighing in on this rule of law question, or do you not see that at all? Because I always think, well, at some point Wall Street's going to have a freak out, and that will be one thing that might sort of keep Trump from going in that direction. But
people are concerned, but they're afraid to say something. Let's just be direct about it. This is a deep concern to a lot of folks, whether it's a law firm or financial firm. If the rule of law is what should guide what is right and what is wrong, the rule of law should guide what you do and what you don't do. The rule of law should determine accountability and the outcome of behaving badly. But right now, there's a perception that it's not about the rule of law. It's about the extent to which you can incur favor with a decision maker. And I think that is really risky and is causing a great deal of concern, the population at large, but certainly for the business community, because it means they don't know what the rules are. They don't know if they're going to be held accountable. And it's difficult to make investments without the predictability of rules. If you want to, it's one thing to say you want to drive anywhere you want to drive. It's another thing to say we shouldn't have stop signs, red lights, and lines on the road that keep people in lanes. We need that in order to be a functioning society.
I think that's exactly right. And I just want to linger on this point of people being afraid to speak out, right? I mean, I think we're seeing it in our industry, right? The legal industry. We're seeing it with Wall Street firms. And I think it's just a matter of time before the real economic consequences of this climate start to play out in ways that are unmissable.
There's one thing that I also think is interesting, a debate on Wall Street, which I think is a good, I think it's an interesting lens to view the Trump administration, which is he going to be successful in pushing for Main Street over big business? Big business is afraid, they are worried. Um, I'm pretty skeptical that he's going to pull off a Main Street an economic agenda over the long term that ends up being good for Main Street. I want to leave my views aside for a second, but I'm curious to get your perspective, the two of you, on this Main Street versus big business. There's a Wall Street trade, but just this general consensus that, hey, that's the big thing that Trump is really about, and how you think that plays out. Obviously you've thought about antitrust and labor and all these different. You've looked at all these different markets, healthcare, and you're a private citizen now, obviously. But what's your take on how things are going in terms of whether or not it looks like it will be a Main Street victory, which I think includes small business, workers, and I guess manufacturing industry, sort of the hollowed out industries of the past. How do you see this playing out? Uh, uh, you know, with Trump 2.0.
I think that I think it's going to be a mixed bag. I think going back to the point about some inconsistency in policy, I bet you'll see some actions that look pro worker, pro the little guy, but there are others that are hard to believe will help Main Street. Um, what is the impact of tariffs on farmers who really need to be getting their fertilizer right about now? Right. We know there are two companies that dominate that sector, but there's a whole import environment that is going to be negatively impacted by tariffs. And so, what is the solution for those farmers when it's growing season right now? For the auto workers, right? There may be tariffs that are helpful to them. And then there's, the kind of like situational tariff. They're on one day, they're off the next day, right? That can't be good for certainty and bargaining for anybody, right? Whether it's a larger corporation, workers, small business, etc. Um, Again, I think there are some actions that will be catastrophic for ordinary people, right? The gutting of the CFPB strikes me as particularly harmful for people. Um, Folks are buying groceries on their credit cards, right? If the administration acts to remove caps on credit card interest and fees and makes it easier for financial institutions to rip off ordinary people, that will have terrible consequences on working folks. Most of the sentiments I've seen, recent statistics and polling suggest that people are more fearful than they have been in decades about being laid off, right? People are more fearful than they have been about losing their homes, right? There is a construction industry that's seeing incomplete construction of new homes. And that reflects something about the economic outlook and sentiment of people. And so I think all of these policies and like their resonance with the American people all point in one direction, right? And so um, I'll go back to my original answer, which is I think it's going to be a mixed bag, but there are certainly some big blows we've already seen to ordinary people.
Yeah, I agree with the mixed bag. I mean, there's a real fundamental question: um, people are people in service of corporations, or corporations in service of people? And I think for the last 40 or 50 years, we've sort of taken this sort of, colloquially a term trickle-down economics approach where we do what's good for corporations and then hope that it drips down to people. I think we got to get away from the drips. Let's do people first policy. And I think there are aspects of the administration that have that clarity, but then there are many that don't. Whether it cancels each other out, whether they cancel each other out, I think it remains to be seen. But I'm not particularly optimistic. I'm optimistic on the antitrust front, but
Yes.
on other fronts, I'm more pessimistic.
And what's next for you? I know you have a recent announcement, a new gig. Would love to know what you're going to be working on there.
Are you going to be a podcast intern too?
Sadly, no. I am going to be a senior fellow at Berkeley Law. And I'm really excited to be doing that for a few reasons. First is that I get to work with my friends Seth Brotman and Sam Levine. They were respectively the general counsel of the CFPB and the head of the Bureau of Consumer Protection. And so together, we are going to work on issues of antitrust and competition, consumer protection, monetary policy, consumer law, and these adjacent areas that have really been siloed for a long time and try to break down barriers. I think I've often fallen into the trap in the past of thinking of consumer protection issues as kind of downstream of market power problems, but I actually increasingly don't think that's true. Sometimes antitrust is not the easiest or best framework for tackling certain problems. Like surveillance pricing, for example, may be an antitrust problem. It might be a consumer protection problem. It might be a privacy problem. We're going to need to bring the best of a lot of different fields to tackle these like new economy problems. The other thing we found is that talking to students was really one of the best things that we did during our time. There is so much excitement and so much hunger for antitrust learning and opportunities. And I think, for all of us old people, I'm an aging millennial, I'm washed up, but the youth give me a lot of reasons to be joyful and excited. And so getting to engage with students and faculty will be very exciting. So I'll be based in DC still, which is my home, but I'll be out in the East Bay several times a semester.
Very cool. Well, I can't thank you enough for doing this. This has been amazing. Get both of you in the same room with Jonathan as the intern here. I like that power dynamic shift that we've got. And it was a great conversation, and thanks so much for doing it.
Start the war planning now while
Oh,
rolling, or
gosh.
afterwards?
Too soon, man. Too soon.
Well, thanks again. This was awesome.
Thanks, Teddy.